Andrew Little.
Mr. Speaker, if there's one thing that this bill does, it doesn't take us to the 21st century, it takes us to the 19th century. I want to give the member who spoke just now one concession. That it is true that the party on that side, the National Party in government, does have a connection with unions. Let me see now. They belong to some of the most powerful unions in the country. Mike Sabin, a former member of the Police Association, a very powerful union. Michael Woodhouse there, and I think even Mr Bennett himself, former members of the Institute of Chartered Accountants, very powerful union, collectively organised. You've got the Attorney General, Chris Finlayson and Kate Wilkinson, members of the Law Society, another powerful union. Even Simon O'Connor, a member of the Catholic Church, probably the most powerful of all of us. And so, sir, they do understand about organising in their own interests, but the difference between them and us is that we look after working people and their interests, those who have to stand up to those in authority to look after their own. Mr Speaker, this bill proceeds from the false premise that a level playing field now needs to be created, as the Minister said last night, or a level playing field needs to be restored. And the implication, of course, is that there isn't presently a level playing field in employment. Well, I've got news for the Minister and indeed for Mr Bennett, who told us that we're boldly moving into the 21st century, and that is that the employment relationship is not equal. Never has been, never will be. It is inherently unequal, and the Attorney General will know this because he is a man of law and a man of letters, and he will know what the origins of our employment law are. It starts with the common law. It doesn't start with statute, it starts with the common law. And the common law of employment, that goes back at least 150 years, is still the law in this land, and it is amended by statute. Let's go back to the common law, because it still applies. It recognises that the employment agreement is a special agreement, because it means one thing, that one party, the worker, submits to the authority and control of the other. There is no other contract that does that. No consumer contract, no commercial contract requires an individual to submit to the authority and control of the other and to limit their freedom as a result. It is an agreement to submit. It is an agreement to submit to the instruction and control of the employer. But it is not an agreement of servility. And decades and centuries of employment law tell us that the employment relationship is not a relationship of servility. But the reality is that the common law was never good enough to hold back the worst of exploitation and the worst excesses of employers. And let's remember too how the common law described the employment relationship. It didn't use the modern 20th century and 21st century language of employer and employee. It used the very raw language of master and servant. It is the common law of master and servant. And if you want a good depiction of how that operated, you only have to look at Upstairs, Downstairs and the more recent rendition of it, who's Downton Abbey. That's where actually, that is where it all stems from. So what did the common law inadequately do? It set up half a dozen duties. 4 duties on workers and 2 duties on the employer. The duties on the workers were the duty to obey. That is the inherent thing about the employment relationship. You are obliged to do as you're told. That's the relationship of submission in the employment relationship. As well, it says you've got a duty of personal service. You have to do it. You can't contract it out to somebody else. You have to do it yourself.
Order.
There's the duty of fidelity, Mr. Speaker. And of course, it's not you, Mr. Speaker. Wouldn't require you to submit to anything other than the authority of the Great House, the authority of the will of the people, Mr. Speaker. Do we know that what you're here for? The other duty, Mr. Speaker, is the duty of fidelity. You have to act in good faith to your employer, and the duty of confidentiality. You understand how all this came about through servants and the master-servant relationship. The duties on the employer were the duty to pay wages, and that was periodically and as agreed, and the duty of a safe system of work. But as I said before, Mr. Speaker, that wasn't adequate. And so statute law had to intervene to protect workers and what freedoms they were allowed to exercise. The freedom of association, the freedom to organise and join together with their workmates, the freedom of choice. Also the freedom to bargain collectively. And these were so fundamental and so important, they have been recognised internationally in international agreements and now celebrated each year at the International Labour Organisation, the ILO, and their annual conferences. The history of employment law is the history of progress towards a more sensible and constructive and collaborative relationship between workers and their employers, or a regression back to master-servant. And, Mr. Speaker, the disappointing thing is that this government, every law change it has made in employment law, has taken us back towards master-servant. This is the government of master and servant. That's the only employment relationship they know. More servility, more submission, more control, more master-servant. That is the National Government 2013. They know nothing else. It is old-fashioned, it is old hat, it's 19th century, it takes us backwards. Mr. Speaker, and we know what their attitude towards unions is. It was represented by Cameron Slater. He said he was pathological about unions, had a pathological hatred. Well, he's right about one thing. He is a sociopath, we know that. But he has a pathological hatred of unions. That defines, and he is the biggest PR machine for the National Party. He defines them. And his biggest hero was, of course, Judith Collins, the Minister of so-called Justice. Can you believe it? So the challenge of modern management is to harness discretionary effort. Good managers, good employers know this, which is why they don't buy into the tardy old, grubby old National Party of old, like the present lot. They buy into modern management techniques, which is about harnessing discretion, getting the best out of people, through mutuality, through mutual respect, through working together, through collaboration, through respecting the choice of workers to belong to the unions they wish to belong to, through respecting the choice to bargain collectively. What does this lot do? They introduce a law, sir, Mr. Speaker, that allows employers to trot off the Employment Relations Authority to stop collective bargaining, to deny the freedom of choice of workers. And what is the interesting thing, sir, Mr. Speaker? We've had the principle of good faith in operation in this country for, 13 years now. 13 years we've had it. And when the employer trots off to the Employment Relations Authority under this bill to stop collective bargaining and frustrate the freedom of choice of workers, a number of conditions have to be met. But there is not one condition that relates to good faith, the requirement of good faith. And the Attorney-General will know, because he's a sensible man, the Attorney-General will know that our employment jurisdiction is defined by equity and good conscience. Equity and good conscience. And Mr. Finderson QC will know that that he or she who comes to equity, they who come to equity come with clean hands. We have to talk about it in the plural these days, so we're talking about at least 4 hands. They who come to equity come with clean hands. But when, under the National Party 2013 bill, when you go to the Court of Equity and Good Conscience, you don't have to have clean hands. That's what they represent. I'm going to talk very briefly about the power of the employer to penalise workers who take what is called a partial strike by deducting their pay. In 2008, the EPMU led a piece of industrial action with Air New Zealand and with flight attendants employed by a subsidiary called Zeal 320 Limited. What they did, their strike action was, and it was defined as strike action, they had to give notice, they decided to breach the dress code for Air New Zealand. They turned up to their shifts, they flew on the planes, they hosted passengers, but they turned up in feather boas, they turned up in flash pink gears, and that was just the blokes. They turned up in fancy clothing. 1 or 2 even had tarmokos on them, and they were allowed to fly. Not a single flight was disrupted as a result of those flight attendants and their partial strike. Not a single passenger was turned away. The company continued to make money, but it was a partial strike. And that had a lot of it was a difficult dispute. What it led to ultimately was a brilliant relationship, a constructive relationship, and a collaborative relationship. But under this bill, those workers will be penalised for standing up for their rights, a better deal, and greater equality. That's how insidious this piece of legislation is. That's how far behind the 8 ball and the Times National Government 2013 is. This is a terrible bill. It is a dumb bill. It's a silly bill. The members opposite know it. They'll shamefacedly go through the process tonight. They know it's wrong, and we will oppose it with all the fibre in our bodies.
That man should be leader of the Labour Party.
It's a green call.
And MP for Rockville.
The members should call. I will... Look, sorry, I think we need to clarify something. The members should call. The Speaker will determine who gets the call. Just because someone else stands up, and we have a sort of rational approach to doing this. Denise Roach.
Thank you, Mr. Speaker.